then we're trying to avoid essentially the assets being sold. And we needed some breathing space. So I would argue CTP should be pursuing some form of legitimacy to allow CTPs to administer a company, implement change with sufficient protection for the company, and possibly not protection for them, because that way they're on the hook. You know, we should be accountable for our decisions. And in saying that, I believe we should somehow be seeking to be allowed to implement a moratorium, so that creditors cannot take legal action against the company, albeit with some degree of oversight or what have you, while we initiate a CVA or a restructuring plan or a consensual restructuring. And that will need some sort of, you know, training wheels to make sure that we don't abuse it. I believe it should be a qualification like a CTP to allow it to happen. Lawyers are advising insolvency practitioners not to take on moratoriums because they're suggesting that insolvency practitioners can be held liable. I personally think leadership is all about taking responsibility for our actions, and therefore we should feel comfortable taking responsibility for our actions in turning around a company, but we need protection from the court.
And thank you, Tony. I really value your directness there, and I think that was the direction of my travel, which was how could we as the EACTP, personally, I agree with you, get to a point where we need to take some responsibility to get to a point of even being a monitor in a moratorium. I agree, and that's why, you know, I was hoping those questions would get us there. Any other views? I appreciate that's a UK-centric view. We do have sort of the WOA, which has 40 hours of training for CTPs to become, to be recognised by courts. We've got the same in Italy. I think it's 60 hours from memory, and maybe that's one of the things we should be looking at.
But it's interesting because for a CTP, obviously we take as a CTP myself, we take accountability and responsibility for the actions that we take on a close those sort of negotiations, and then you try to deliver the turnaround within the consensual agreements that you have with your creditors. But obviously legislation will help if also in terms, like if we were to talk here about in the UK, the restructuring plans, making it more accessible, and also for lawyers to support the work that we do, and convince the insolvency practitioners, who are ultimately at the moment the supervisors on the moratorium, that we can actually support the process. And that is, I don't know how we can actually achieve it unless it's for lobbying, but also insolvency practitioners have their agenda, and it's all parties are pulling their way rather than pulling onto the main stakeholders' way. And that's the only barrier I see for us to actually see be more established or be more recognized